Get ready for the dictation. Dictation will start in 5 seconds. Start. Now, before finally making a construction or interpreting the concerned provision, the differences or similarities in both the provisions of law, that is section 25 under bracket 4 and section 25 under bracket 5 is required to be considered. In both the situations, that is, if no confidence motion is passed against the Chief Counsellor, Deputy Chief Counsellor under section 25 under bracket 4, or if such incumbents of such offices are removed under section 25 under bracket 5 of the Act, the net result would be their removal from the respective offices. However, the question is whether there is any similarity in their scope, ambit, and nature. In my view, answer has to be in negative. There are several distinctions between removal under section 25 under bracket 4 and 25 under bracket 5. Removal under section 25 under bracket 4 is by way of democratic process, showing the will of the majority of the members of the House of the Councillor / municipality by adopting and passing no confidence motion, and for that a requisition has to be made by not less than 1/3 of the total members of councillors, and thereafter special meeting has to be convened for notifying in terms of procedure laid down under Bihar Municipal No Confidence Motion Process Rules 2010. Under Rule 2 under bracket 4 of the aforesaid rules, it is required that such notice for considering no confidence motion against the Chief Counsellor, Deputy Chief Counsellor shall contain the reasons, allegations on the basis of which the no confidence motion is to be brought, and the allegations contained in the requisition are discussed by the members in the special meeting, and thereafter the motion is tabled, and after voting the fate of the concerned councillor or deputy chief councillor is decided by the majority. However, in my view, such passing of no confidence motion is not stigmatic in nature, as no explanation by the concerned person is required, and though he is allowed to participate in the debate, no finding regarding guilt is recorded. Merely a discussion in the House is held, followed by casting of votes, and majority decides the fate, whereas under section 25 under bracket 5 charges have to be framed, notice is to be given to the concerned, and his explanation has to be considered by the state government, and then only a final order recording a finding of guilt or otherwise is passed. Such order can be put to judicial review, invoking the powers of this court under Article 226 of the Constitution of India. However, removal on passing of no confidence motion cannot ordinarily be challenged, questioning as to whether such decision of House is correct or not, or the motion was fit to be adopted or not, though such decision may of course be challenged and even set aside under Article 226 of the Constitution of India under certain circumstances. For example, if it suffers from any procedural lapse or lacuna, or the relevant statutory provisions have not been followed, etc. Stop.